Hi guys, it's Kathy. I hope you're doing well. I can't adjust my self-centered because it's perfectly set up for the next screen, which is more important by far that I'm not in the middle of a court video. CJ, I hope you're feeling well. I'm not screaming at you, in case you're not. Talking very softly, with no accent. We made it to Monday morning, guys. Monday morning. Blah. I have off today, so I'm happy. Today's my day off. All right. We're going to do one judge today. And then that's it. But we like this judge, so it'll be fine. Here we go. See, I'm better centered over here. I would have to change it.
All right.
Monday has been canceled, says Bobby.
All right. Off of the 5E docket, number 2, 24 CR 7726.
Do you think it's the beard that he got the beard going on? And the chief judge is like, you can handle 2 dockets today. So he's doing 2 dockets? I don't see how. Guys, I don't even know how to tell you. I know I tell you before, but I don't think you understand. Because it's not easy to understand. His dockets are over 100 people. His dockets are so long. He works from morning until late.
Eaple versus Dean. Entries.
Stephen Fritz for the people.
Good morning, Nicholas Given, Your Honor, for Mr. Dean, who's present out of custody. Your Honor, we're on for arraignment.
And we're 283 days into this case, and we are still at arraignment.
It's wild. I agree. It's
We
been
ready to set trial then?
we have
For Georgia, that's like that's every single case. That would be golden for every single case. People would die to be arraigned at 200 days in Georgia.
we can set trial. It's going to resolve. I'm happy to move forward however the court wants us to.
Well, if you're telling me you're 96.2% of the way there,
We're waiting on a restitution number from a 21-year-old victim, which is why the restitution number is slow in coming.
Your Honor, we just learned within the last couple of days, Stephen Fritz for the people. We just learned from the victim within the last couple of days that she's seeking restitution for some lost wages. And I know as of yesterday, she was in the process of getting some kind of documentation on her company letterhead to set that out. And I expect we'll have that within a week, if not today. And I think I could probably speak for both parties that we are more than 96 point, I forgot the decimal point that you mentioned, sure that we are going to resolve this.
all right, well, let's get the paperwork filed. Let's get it done. Restitution is what it is. That's going to kibosh the deal. Let's set it for trial. If it's not going to kibosh the deal, let's get it done.
Understood.
What's a good date? What's November 7th for a plea? We'll
That's fine with
Continue
me.
the arraignment to
April the
November
2nd is a
7th. You
good
want
date.
8:30 or 1:30? Or does she do both?
8:30, please.
8:30 in the morning on November 7th. Continued arraignment. If we're gonna have a disposition, let's get the paperwork filed and let's get it done. Restitution is a matter of statute. It's either gonna be owed or it's not.
Understood. Thank you, sir. Appreciate it. Of course.
Judges is 5, 6, and 7, Kenneth Goick.
That's enough, sir. Let him ponder. I would like to see him and Crawford on a panel of judges for a case where they can both ask questions and ponder. Who would the lawyers be, though? Thank you so much for the bits, Maria. I appreciate it. Look at all those
All
hearts.
right, 5, 6, and 7 on
Monica,
the
thank you
4G
for the-
docket, 24 CR
No, no.
3233, 24 CR
Thank you, though.
6134,
Thank
25
you.
CR 2536, all people versus Gulick entries.
Daniel Cohen, on behalf of people.
And Alan Whitlock, appearing for Mr. Gulick, who is present in custody for sentencing today. We are prepared to proceed to sentencing.
All right, go ahead, Mr. Cohen.
Thank you, Your Honor. As the court is aware, Mr. Gulick presents kind of a complex situation in that he pleaded guilty to 2 of the cases with an agreement to a cap of community corrections and the stern warning from this court about needing to follow through. And then in the interim, after pleading guilty, but before being sentenced, he was arrested and charged with a new offense, which he has subsequently pleaded guilty to. My understanding is that, and I spoke briefly with defense counsel about this, I believe that we're proceeding today with open sentencing on all 3. And I just want to make sure that we're
Hold on, give the judge a second. He's gonna need... This judge is gonna need a second to compose himself. They just gave him an open sentence. Guys, the prosecutor keeps stipulating, okay? Him and all the defense lawyers, they stipulate to caps. Okay, we're gonna plead guilty, but there's a cap of 8 years. We're gonna plead guilty, but there's a cap of 2 months. So the judge, you know, has to stay within those caps or reject the whole plea deal. And the judge does not like it. He constantly says, I'm sick and tired of you guys deciding the sentence. I am the judge. You guys decide the crime. I decide the sentence. This is not your job. This is my job. And he's like, and I gotta go with your stipulations because all these other judges are going with your stipulations. But this is ridiculous. You have to stop with the stipulations and the caps. I will decide the punishment for the crimes. I am the judge. So we are opening today. I think they said he had 3 cases. I'm completely cut off over there. Jeez. 3 cases. And they're all open pleas. This judge, I don't know. He's not going to be able to handle that. Let's see how he does.
all on the same page with that, and that Mr. Gulick is aware and affirming that that is in fact the intention, because the fact that we had not proceeded yet to sentencing on those 224 cases, I just want to make sure the court is still that essentially we are on that same page. So if we could just affirm that, and then I'll proceed with my argument.
And he failed to appear for sentencing anyhow.
That is, and then there was that, yes.
So,
And Judge, my understanding is that these cases all represent a range in the enhanced range based on the pleas to the felonies, and that the cap of community corrections is no longer before the court. Mr. Gulick, having been advised, is asking to affirm his pleas, understanding that the maximum sentencing range in this case would be up to 14 years in prison, with community corrections and probation both being options for the court to sentence him to.
So that being said, Your Honor, Mr. Gulick has a fairly extensive drug conviction history, and his performance while on these cases is unfortunate and troubling. Looking back at history, there's a lot of possession of controlled substance offenses.
Okay, Judge, don't care about that.
Non-drug cases involve a vehicular assault, DUI from
he cares about
2018,
that.
a menacing from 1989, and a theft from 1990, and an attempt theft from 94. So he has a lengthy.
1989 now? I mean, the one the judge is going to care about the most is the menacing from 1989. But it's from 1989. The other one is the DUI. I didn't hear what that was from. The judge is absolutely not going to say you know, he's a criminal because of the drug charges. No, he won't. He'll say you need rehab for the drug charges. But he was out. He pled, and then he was out waiting to be sentenced, and he picked up another case, and I don't know what it is. Three. And well, no, sorry. He picked up another case. He pled guilty to that. Now he's here for 3 probation violations. All right. Capped to 100 years. That's right. That's right. This is a limited time series out here, only on YouTube. Court Vibes will only be around for 100 years, people. It's already been 2, so okay. Let's see what he does. I don't know what he's gonna do.
Criminal history.
Hold on.
Based on his performance and his history, at this point, the people are asking for a Department of Corrections sentence. I believe that 8 years would be appropriate, and I would believe I would be asking for 3 years on each of the 24 CR cases and 2 years on the 25 CR case, all set to run consecutively. There's no restitution in any of the matters.
Ms. Rillat?
Thank you, Judge. First, I just want to note the applicable pre-sentence confinement credit for Mr. Gulick in each of the 3 cases. In 24 CR 3233, he has 70 days of credit. That's the 60 days noted on the pre-sentence report, plus the additional 10 he's been in custody following the failure to appear in arrest.
I'm sorry, how much was that?
That's 70 days. In 24 CR 6134, he has 105 days of pre-sentence confinement credit. Again, that's 10 additional days to what's noted on the PSI.
I'm
And
sorry,
then
I'm trying to get the notes down.
Sorry, I can go
100 and
slower.
what?
105.
105,
And then in the new case, the 25 CR case, he has 27.
27 days.
Judge, one of the things that I've been impressed with Mr. Gulick about, notwithstanding the failure to appear at the most recent court date, is that is no secret. He struggles. He is an addict. And that's what he is before this court for. He, after picking up that new case, bonded out, and I assumed that I just wouldn't see him again, having known that he was pending sentencing, picked up a new case. But he came to his preliminary hearing without me contacting him because I didn't have contact information for him, and then came to a couple of subsequent court appearances in the district court while we tried to work things out. And so I know that this is something where Mr. Gulick, he made the comment to me that he's tired. Certainly he's tired of going to jail, going to prison. He has spent the vast majority of his adult life in jail, in prison. That's understandable. He's tired of picking up new offenses. He's tired of making poor choices. He's tired of being around people that allow him and enable him to make those choices as well. But he's also tired of having a lack of stability, and he's tired of struggling with mental health and substance abuse. And you know what Mr. Gulick told me is it's not that easy when I met with him before sentencing. And I think there's a lot of truth to that, because the reality is Mr. Gulick did participate in that intensive residential treatment down in Pueblo, but he only did the 30-day track. He didn't continue with that care at a sober living facility, and he didn't continue with it. And he made a mistake I think a lot of people do, which is, I've got it. This was helpful for me, but I'm tired of doing this, and I can do it on my own. And I think the record before the court in this case, in all these cases, frankly, and the record from his pretrial report with the numerous felony convictions indicate that he doesn't have it, and he can't do it on his own. But the reality is, if it were that easy to just have the desire to get clean and sober and have housing, if it were that easy, our courtroom would be half as full as it is today. And frankly, Judge, that is exactly what the divert court is for, to have intermediate sanctions, to be very hands-on, to be very proactive in terms of correcting bad behaviors and correcting certain thinking patterns in real time and as it happens, to hold people accountable. So I'm asking the court today to either consider sentencing Mr. Gulick to the divert program with a suspended sentence, understanding that the court does have 90 days of jail as a condition of probation in each case, and can not only fashion a rehabilitative jail condition through the RISE program, but also a punitive jail sanction for his failure to appear at the sentencing date. In the alternative, I'm asking the court to consider sending Mr. Gulick to community corrections. One thing that does stick out about his history is it's nonviolent. He had a 1989 felony menacing case, a GS assault from 2014, and then a vehicular assault from 2018. And certainly while it's an assault case, again, that goes to the idea that Mr. Gulick is driving when he shouldn't be, when he's intoxicated, and he's harming other people in that manner. But Mr. Gulick does not present as somebody who is out actively harming the community through violence, through crimes of violence. I also think that while he is here today for 3 distribution cases, those distribution cases are a little bit different than somebody who is actively earning an income.
No, he's toast. He's toast. He's there for distribution. He's not there for doing drugs. He's there for selling drugs. 3 different. He was in between. He was about to be sentenced. He's toast.
And who is actively seeking to deal drugs as part of their lifestyle. One of the cases was charged as a DF1. I did the math and the measurements. It was a DF1 because he was 955 feet away from a school. He was actually with the co-defendant, Donio Johnson, who I believe the court is very familiar with. Mr. Johnson is a prolific drug dealer in the city and county of Denver. And Mr. Gulick, my understanding, was with him in helping to facilitate a transaction when the arrest occurred. The other 2 cases, Judge, Mr. Gulick was approached by a confidential informant on Colfax. He had drugs and basically sold a small amount, $20 worth and $40 worth of an own personal use in order to have enough money to eat and to buy more drugs. So this is clearly somebody who is selling to support a habit. Finally, I talked to Mr. Gulick about what happened that day, because had he come to sentencing, this would have been a probation sentence with 90 days of jail, as the court previously indicated, but we had needed to set the case over just to have that updated divert screen or letter from divert. Mr. Gulick indicated to me that he was on his way to court. He received a call from his daughter that morning letting him know that she was going into labor. He also had previously let me know that one of the reasons that he didn't continue that sobriety court or the sobriety treatment track is because he wanted to be present with her when she was pregnant earlier. He was walking from York and Colfax down here, getting ready for the remand, talking with me in real time, and he ran into somebody from the streets that he knew. And I think the court knows where the story ends, is he made a choice to get high instead of dealing with this. And he intended to come after he made that decision and then ultimately chose not to. Since that time, Judge, Mr. Gulick has overdosed on fentanyl, and he has actually lost a friend to a fentanyl overdose. And so not only does the choices of substance use and in terms of his criminal exposure, that's becoming a very real reality and has been for a while, but he's actually seen people pass away and has been very close.
Did he sell them the fentanyl? Did he give them the fentanyl?
To passing away himself, indicating that he actually had to receive multiple Narcan treatments in order to be revived. I don't know. Let me rephrase that. If the court sentences Mr. Gulick to prison, he will get out and he will continue to have the same issues. I don't believe that Mr. Gulick presents such a public safety risk to this community that the court can't try something different first while having that DOC exposure over his head. For instance, the court can sentence him to divert, understanding that if he is unsuccessful, he will go to prison, and the court can choose the length of that suspended sentence. The court, as I previously indicated, can impose jail as a condition of probation to have the RISE program completed, but also to add additional time as a punitive sanction. If the court's not inclined to do that, Mr. Gulick could go to community corrections, and the court could determine today if he is rejected from community corrections before acceptance, that probation is not appropriate and it is an automatic DOC sentence. Alternatively, the court could fashion a community correction sentence that is long enough to where Mr. Gulick would face a lengthy prison sentence if he were unsuccessful. But ultimately, Judge, this is an individual who struggles and who does need help but doesn't quite know how to do it himself. And I don't believe he presents such a significant public safety risk that we can't try to correct these issues with a punitive and rehabilitative sentence. Thank you.
All right, Mr. Gullick, and you are reaffirming your pleas and you want to move forward with sentencing?
Yes, sir.
All right, you have the right to tell me anything you'd like me to know.
Yeah, I messed up, you know what I mean, for not going to court that day,
Yep,
but I got high and,
there's a song about that.
so,
Go ahead.
but, you know, I made a mistake, you know?
You know, and the question really is, how often and how long does society have to bear the burden of your mistakes? That really is the question. I, in reviewing your cases, wrote down from day one, these were prison cases. We're talking felonies 12, 13, and 14. And it's not just that you're only harming yourself. You are harming others. The vehicular assault shows that. And the bottom line is you're dealing. And your attorney had convinced me to do something different. And then you just didn't show up. So, no, you're going to go to prison. Yeah, and it's just about punishment. And you're going to decide whether you're tired of this or whether it's going to keep happening. You come back to me on felonies 16, 17, 18. We're not going to talk about diversion. It's just going to be back to prison, period. You know, you started a program, you opted to get out. You can second guess that decision all you want, but that was your decision to leave the program. We have thrown resources as much as we can at you. I can order people to do classes. I can order people to do ComCore. If you don't want to stop the drugs, you're not going to stop the drugs. I know it's hard, but I'm not seeing effort. I'm seeing putting myself into a program and then deciding, oh, I've got something else going on, so I'm going to leave it. So this is more important than that. And then I told you I was giving you a chance, and with that golden opportunity, you know, you just blew it off. So enough's enough. You don't need hear any more from me. On 24 CR 3233, I'll sentence you to 3 years in the Department of Corrections. In 24 CR 6134, I'll also sentence you to 3 years in the Department of Corrections. Each of those are going to be consecutive to each other, which basically means you're going to do about 1.8 years on each one consecutive, so that you'll end up doing about 3 years. And I think that's probably enough, contrary to my normal inclination. On 25 CR 2536, I'll sentence you to 2 years in the Department of Corrections, but that will be concurrent to the 24 CR matters. So that will cut some time off of your sentence. In the 25 CR 2536, we will note the 27 days of pre-sentence confinement credit yeah, it's a DF4, so 1 year period of mandatory parole. On 24 CR 3233, we'll note the 70 days of pre-sentence confinement credit and the 1 year of parole. And in 24 CR 6134, 105 pre-sentence confinement credit and 1 year parole. Look, Mr. Gullick, I really hope that everything your attorney said is accurate and that you're tired of this and you really are ready to deal with this, because you are getting too old for all of this garbage. Good luck to you.
Oh, I knew it. I knew he was going to jail, prison.
Turn on our camera. Counsel.
Your Honor, we're ready on Miss Jennifer Hammond. She's on the 5E docket. Should be on the add-on.
Excuse me.
This was the 11th. Why is he doing other people's dockets? Oh, Saturday. He did this on Saturday. I think. Hold on. Just everybody calm down.
It's that one.
Let me look, see when he did this.
All right, court will call 25 CR 840, People versus Hammond. Entries?
Stephen Fritz for the people.
Samantha Harris on behalf of Miss Hammond, who appears in person on bond.
All right, I've got paperwork filed with the court. Is that what we're doing?
Yes, Your Honor.
Oh, I
And
know
I've got
where it
paperwork
is.
here indicating, ma'am, you wish to plead
Hold
guilty
on.
to a class 1
Friday.
misdemeanor
Friday.
of menacing. Looks like there's an agreement your attorney and the district attorney are asking me to accept, which would see you sentenced to 2 years of probation with certain conditions as outlined in the agreement, to include 1 year of jail suspended. Is that your understanding of what you're doing?
Yes, sir.
Why don't you do me a favor and swap so that you can get closer to that microphone, pull the mic, point it at you, pull it closer, and make sure you're speaking right into that for me.
I said, yes, sir.
Counsel, you wait further advisal under Rule 5?
I do.
All right, and you are Jennifer Hammond?
Yes, sir.
How old are you?
39.
And how far have you gotten in school?
A little bit of college.
All right, so I ask that question to everybody because the paperwork's in English. Obviously, this hearing's being conducted in English, so I like to make sure everybody reads, speaks, and understands English, so I presume you do.
Yes, sir.
Are you a veteran of the United States military?
No, sir.
Are you under the influence of any medications, drugs, alcohol, anything that would be affecting your judgment today?
No, sir.
Counsel, you have a constitutional obligation to find out the nationality of the citizenship of your client. And if your client is anything other than a U.S. citizen, you have a constitutional obligation to inform her of the immigration consequences this specific plea would have on her specific immigration status. Are you in compliance with your obligations?
Yes, Your Honor. She has been so advised.
The count to which you are pleading guilty reads that on February 10th, 2025, you, by any threat or physical action, did unlawfully and knowingly place or attempted to place Charlotte Hammond in fear of imminent serious bodily injury. To that count, would you plead guilty or not guilty?
Guilty.
And before I accept that plea, let's make sure that you understand a couple of things. First off, you understand that a class 1 misdemeanor carries a maximum sentence of up to 364 days in the county jail.
Yes, sir.
So even though technically the Rule 11 says 1 year suspended, it would be 364 suspended. Does she have a copy of the paperwork there in front of her?
She does not, Your Honor, but I can pull it up.
All right, so you went over with your attorney a document called a request to plead guilty, or Rule 11 advisement. Your attorney's fixing to pull that up.
Sir, you're in Colorado. Your attorney's fixing to pull that up. You need a way thicker accent to use those types of words.
Yeah, she did go over documents when I came down and signed the papers.
Yeah, if we can get it in front of you, that'll make this a little bit faster, but if we can't get it pulled up here, we'll do it the long way. All right. You have the right to plead not guilty. You have a right to a public trial within 6 months of that not guilty plea, and you have a right to be represented by your attorney at all hearings up to and including trial. If you can't afford an attorney, one would be appointed to represent you at no cost to you. You have the right to be presumed innocent of the charges, and you have the right to have the DA prove the charges beyond a reasonable doubt. At a trial, you would have a right to confront witnesses that are called to testify against you. That means you have the right to question them. You have the right to present evidence in your own defense, and you would have the right to have me or Judge Schutte issue subpoenas ordering your witnesses to come to court and testify during your case in chief. At a trial, you'd have the right to testify or not testify in your own defense. And if you chose to remain silent, the judge would tell the jury that the jury could not use your silence against you. Finally, if you went to trial and you were convicted, you'd have the right to appeal that conviction to a higher court. That means you'd have the right to ask a superior court to review every decision the judge made, everything that happened during the trial, make sure it was all legal. Do you understand that you have all of these rights?
Yes, sir.
Do you understand if I accept your guilty plea, you're giving up all of these rights? There is no trial. You're guilty. We're going to sentencing.
Yes, sir.
All right. Finally, I do not accept pleas of guilty from people who tell me that they've done nothing wrong. I mean, that's what trials are for. So now I'll ask the DA to tell me what facts he would prove at trial that support this charge. And when he's done, I'm going to ask you if that's what happened. Counsel.
Thank you, Your Honor. In this case, the defendant chased the victim, her mother, out of her mother's apartment with a knife.
Is that what happened?
Yes.
All right. Understanding the rights you're giving up, understanding the potential penalties, do you still want to do this today?
Yes, sir.
All right, then I will accept your plea, find that you've entered into it knowingly, intelligently, and voluntarily. Anything else to add as to sentencing? Prosecution?
Not from the people.
Defense?
Your Honor, I would just note that this is an offer that was extended in recognition of the work that Ms. Hammond has done. I think she will be successful on probation based on the resources she's managed to engage with on her own. And I think this will be the last time this court sees her.
All right, ma'am, you have the right to tell me anything you'd like me to know.
I'd just like to apologize, and I feel truly I'm doing a lot of things to try and take steps to like mental health and recovery, and just being slow and trying to not make anybody uncomfortable. And, you know, I accept responsibility and they won't happen again. And I
Yeah.
apologize.
Seems we always hurt the ones closest to us, right? Mama didn't deserve any of that.
No.
All right, I'll accept the proposed disposition. I will sentence you to the 2 years of probation. The condition of probation is continue your mental health treatment. That's, that you've got going and that, probation requires of you. Pursuant to the agreement, I will suspend the 364 days in the county jail. Look, the mental health aspect, well, you know better than any of us, but I've dealt with it in my family, and it's
Bobby,
hard. You
you're
start feeling
guilty.
better, then you
Bobby,
stop thinking, you start
guilty.
thinking you don't need to do certain things anymore, and that's when things go bad.
Well, I got
Just-
into
just stick.
it, and I've done 2 classes already.
Oh,
A
good.
phone interview and then 1 in-person session already.
All right, excellent.
And I have another appointment on the 17th.
Good. All right, I hope I don't see you back. I need you to report to probation. It's at 303 West Colfax. I presume there's no restitution.
No, but if I may have one moment, Your Honor, I just want to ask if there's anyone on the WebEx, if the victim is on the WebEx. Charlotte Hammond, are you on the WebEx? If now, please let us know.
I don't see,
Okay.
yeah.
And I don't see her in the courtroom, so
All right.
I'm good. Thank you.
I'll enter the finding of no pecuniary loss. Go to 303 West Colfax. It's just catty corner from here. Get that set up and don't come back.
Yes, sir.
Have a
Thank
good
you
day.
very much.
It's illegal to get your brother to notarize your forms, Bobby.
Thank you.
Are we ready on number 1 on the 5E docket? The interpreter's here, so I presume council's ready?
Won't see me back. See you Monday, Judge.
I don't even see. Interesting. I don't even see Barragan on here. Yeah. It's not on JPod. Doesn't matter. I can pull it up. Is Barragan Renteria?
I'm sorry, Judge.
Yes.
The audio cut out. Could you repeat what you said, please?
I was calling up Mr. Barragan Renteria.
Convocamos la causa del señor Barragán Rentería.
And sorry, I prepared this docket last night, but I did not see this case, so give me just a moment.
Y preparé el expediente anoche para el día de hoy, pero no vi esta causa. Si me dan, por favor, un momento.
Oh, this is completion of probation and a wobbler review?
Entonces, esto es para
That's the second time I heard that. No, that's wrong. This is an additional time that I've heard that. Not the second, an additional. I don't know how many it was before. Wobbler review? I think we had a discussion. I think we had this exact same discussion the last time we heard it. I heard it. And I think Kelly probably Googled it and we figured out what it was, but nothing is coming to my head right now. Don't know what a wobbler review might be. I'm sure it was because there was a case involving wobbler. I don't know anything more than that. I don't even know that actually.
Determinar si se completó la libertad condicional y una revisión de transferencia de causa.
I will call 23 CR 1315, People versus Barragan Renteria.
Stephen
Convocamos
Fritz.
la...
Sorry.
I'm sorry, Judge.
No, you go ahead.
Convocamos la causa 23CR 1315 contra el señor José Barragán Rentería. Comparecencias, por favor.
On behalf of the prosecution,
Stephen Fritz for the people.
Stephen Fritz con la Fiscalía.
and Mr. Barragan is present out of custody without an attorney.
El señor Barragán está presente estando en libertad y comparece sin abogado.
I know what a wobbler is, and they wobble. They don't fall down.
It appears he has successfully completed his probation.
Entiendo que completó con éxito su libertad condicional.
Upon successful completion of that probation, the court vacates the conviction for the felony and enters conviction on a level 1 drug misdemeanor offense, possession of a controlled substance. This is being done pursuant to 18-403.5.
Entonces, dado que se cumplió con éxito la libertad condicional, se anula la condena por el delito grave y se emite una condena por un delito menor relacionado a las drogas clase 1, que es por posesión, de acuerdo a la norma 18-403.5.
Anything else from the prosecution?
¿Algo más de parte de la Fiscalía?
No.
No.
Well, congratulations, sir. You now have the felony removed from your record. You can't seal the case at this time because there is
Yay.
a misdemeanor conviction.
Entonces lo felicito, señor. Se ha quitado de sus antecedentes la condena por delito grave. ¿No puede en este momento sellar usted la causa porque hay una condena por un delito menor?
We will note successful completion of the probation. You are now off probation on this case. You're free to go.
Entonces, en sus antecedentes va a aparecer que usted completó con éxito la libertad condicional y ya no tiene más que cumplir con este caso.
Any questions?
No. ¿Tiene alguna pregunta?
All right. Have a good day, sir.
Que tenga un buen día, señor. Se puede retirar.
Any other Spanish interpreter matters that we don't see that we have any in 4G? Does not see like there's any more in 5 Echo. So thank you very much. You're free to go.
Thank you, Judge. Have a good day.
I'll raise you have a good day to have a good weekend. Yeah. Does it still count? Does my wishing her a good weekend, is it hanging in the ether?
I think so.
What happens to it? All right. Counsel.
We are ready on Mr. Ty Cates. He's number 4 and 5 on 5E's docket.
No. All right, 25 CR 3288, 25 CR 2333, People versus, you did you say Cats?
Cates.
Cates. Entries?
Stephen Fritz for the people.
Samantha Harris on behalf of Mr. Cates, who appears in person in custody.
All right, so I've got some paperwork filed in each of these cases. Is that what we're doing?
Yes, Your Honor.
All right, so in 25 CR 3288, I've got paperwork indicating, let's see, make sure I got my notes right here. You're pleading guilty to counts 1, 2, and 4. That would be 2 class 5 class 5 felonies for motor vehicle theft and a drug felony 4. And in 25 CR 2333, you'd be pleading guilty to counts 3 and 4, a class 2 misdemeanor and a class 6 felony. Is that your understanding of what you're doing?
Yes, Your Honor.
Counsel waive further reading and advisal under Rule 5.
Yes, Your Honor.
All right, Mr. Cates, how old are you, sir?
27,
And how far did you get in school?
11th grade.
All right, so I presume then that you read, speak, and understand English.
Yes, sir.
Are you a veteran of the United States military?
No,
Under the influence of any medications, drugs, alcohol, anything that would be affecting your judgment?
no, sir.
Counsel, you've got a constitutional obligation to find out the citizenship of your client, and if he's anything other than a U.S. citizen, to inform him of the immigration consequences that these specific pleas would have on his specific
Kelly
immigration
is
status. Are you
way
in
better than
compliance with your
Google
constitutional
every
obligations?
day.
Yes, Your Honor. He has been so advised.
Now she just has to get better than ChatGPT.
All right, in
ChatGPT really makes Google look stupid. I have this little, I don't know what they're called, so I'm going to call it an Echo, but I doubt that's what it is. I have this little Echo in the bathroom. It is used almost solely by everybody in the house as radio. So when we take a shower, we can tell what song to play. So all it does is play music. But you can, it's an Echo, so you can ask it questions and see if it knows the answers. Since ChatGPT came to life, this thing has gotten more dumb and more dumb and more dumb with every single question that I ask it. And lots of times it gives me so bad answers that I just end up swearing at it. And it tells me, it says things like, even though I'm AI, I still have feelings. No, you don't. You don't even know that you don't have feelings. That's how stupid you are. It's frustrating. All I do now is just, you tell it to play a song, and you are super specific about what song you want. No, it can barely function like that anymore.
25 CR 2333. Pleading guilty to counts 3 and 4. Count 3. Hold on 1 second.
No, we're saying you're better than that. You're better than them. Way, way, way better.
Okay. Is a charge of possession of a financial transaction device, a class 2 misdemeanor. It reads between and including April 27th, 2025 and April 28th, 2025. You did unlawfully possess or control one or more financial device, which you knew was lost, stolen, or delivered under mistake as to the identity or address of the account holder. To that count, do you plead guilty or not guilty?
Guilty.
He added count 4 is a class 6 felony attempt to commit motor vehicle theft in the 3rd degree. That reads between April 25th, 2025 and April 28th, 2025 by engaging in conduct constituting a substantial step toward the commission of motor vehicle theft. You did unlawfully, feloniously, and knowingly obtain control over the motor vehicle of George Falks, and you knew that it was without authorization. To that count, do you plead guilty or not guilty?
Guilty.
All right, in 25 CR 3288, count 1, motor vehicle theft F5 on or about June 11th, 2025. You did unlawfully, feloniously, and knowingly obtain control over the motor vehicle of Pedro Cabrera, and you knew that it was without authorization. To that count, do you plead guilty or not guilty?
Guilty.
Count 2, motor vehicle theft, class 5 felony on or about June 11th, 2025. You did unlawfully, feloniously, and knowingly obtain control over the motor vehicle of Che Tompkins, and you knew it was without authorization. To that count, do you plead guilty or not guilty?
Guilty.
And finally, count 4, possession of a controlled substance, drug felony 4 on or about June 11th, 2025. You did unlawfully, feloniously, and knowingly possess a material, compound, mixture, or preparation that contained more than 4 grams of methamphetamine, a Schedule 1 or 2 controlled substance. To that count, do you plead guilty or not guilty?
Guilty.
All right, before I accept your plea, let's make sure that you understand a couple of things. Pardon me. The sentencing ranges aren't
Just
specifically
open a
listed
bag
in
of
the Rule
tuna.
11.
I mean, open a
The
can of tuna.
DF4
They'll come to you.
in 25 CR 3288, are these aggravated, enhanced?
They are enhanced, Your Honor. He was on a deferred judgment at the time.
All right, so we're looking at 2 to 6 then on the class 5 felonies?
I believe they would be 1 to 6, Your Honor.
1 to 6. All right, you understand that each of those class 5 felonies carries a potential sentence of between 1 to 6 years in the Department of Corrections with a 2-year period of mandatory parole?
Yes, sir.
And the DF4 carries a potential sentence of between 6 months to 2 years in the Department of Corrections with a 1-year period of mandatory parole?
Yes, sir.
The class 6 felony, I guess he was on the deferred still, so we're looking at a 1 to 3 years in the Department of Corrections with a 1-year period of mandatory parole. Do you understand that?
Yes, sir.
And the class 2 misdemeanor carries a maximum penalty of 120 days in the county jail. Do you understand that?
Yes, Your Honor.
All right. Did you pull the paperwork up for him?
Yes, Your Honor. I'm not sure which case you would prefer. Both are up.
Doesn't matter. They're the same. In each of these cases, sir, this defense request to plead guilty, the Rule 11 advisement has been uploaded to the court. So we're looking at the same documents. In each of these cases, this was filed. There are initials next to each numbered paragraph. Did you put those initials there?
Yes, sir.
All right. Does that mean you went through this line by line with your attorney?
Yes, sir.
If you had any questions, did she answer them?
Absolutely.
Do you have any questions for me about anything that's in these documents?
No, sir.
All right, main thing I want to call your attention to on each of these, on either of these, On page 2, there's a paragraph 5, and there's lettered paragraphs A through K. This lays out all the rights that you have, your right to be presumed innocent, have a trial, etc. In each case, separately, do you understand that you have each and every one of the rights as listed in this document?
Yes, sir.
Do you understand if I accept your guilty plea, you're giving up these rights?
Yes.
All right, factual basis?
Are you asking the people to recite that? Or,
Yes.
sure. Which one would you like to hear first?
Dealer's choice, sir.
All right. In docket ending 3288, the defendant knowingly possessed 2 stolen vehicles from 2 different victims. He also had approximately 20 grams of meth, and he admitted to the car thefts and to possession of the drugs.
Is that what happened in that case, sir?
Yes, sir.
Okay,
And-
again, the judge, unless it's like a quantity that he's dealing, the judge isn't going to focus on the possession of the drugs. However, car thefts, the judge thinks more like I think. Now, when we were growing up, the charge was grand theft auto. It was like minimum 5 years, no questions asked. If you stole someone's car, that was way worse than stealing their money, their diamonds, their living room television set. Like, people would break into someone's house, burglarize them, and get way less time than if you stole someone's car. Growing up, grand theft auto was a big deal. It was bad. A very bad thing to do. But nowadays, it's just the same as stealing another piece of property from that person. It's not, they don't emphasize grand theft auto. It's not even called grand theft auto anymore, and I always try to remember what it is called. It's like unauthorized use of a vehicle. It doesn't even sound bad anymore. It sounds like, oh, well, that's not a big deal at all. But this judge thinks like I do, that grand theft auto is a bigger deal than, see, I know where it came from. Like, if you stole someone's horse before cars, you got shot, you got hung. They didn't approve of that in the slightest. That was a death sentence, and that just rolled over to when it was cars. But stealing someone's car, I think, is a big deal. It's their livelihood, their way to live. And this judge, I think, I don't know what he's going to do here, but I've seen him before, and he has an emphasis for it. proper emphasis.
In docket ending 2333, the defendant was in a stolen car, and he also had a loaded gun in his bag while on probation.
Is that what happened in that case, sir?
Yes, sir.
And he also obviously had a financial transaction device that was not his.
You agree to that as well, sir?
Yes, sir.
All right, understanding the rights you're giving up, understanding the potential penalties, do you still want to do this?
Yes, sir.
All right.
Kelly, it's just a tool. I think it's just a tool. ChatGPT is just it's like using a hammer to hit a nail. Sometimes it answers questions better. Sometimes Google's fine. Either are fine to use. There's no reason why you shouldn't be able to look up information. We have all the information we want at our fingertips. It should be better to use these things than not use things because they're information, and sometimes they're wrong. Yeah, but you know what? Sometimes we're all wrong. I'm always wrong. I just told you this judge emphasizes grand theft auto. Watch him turn around and give this guy probation, or girl. I don't know what we're doing. I'm just here.
I'll accept your pleas in each case, find that you've entered into it knowingly, intelligently, and voluntarily. Are we doing we're getting a PSI?
Yes, Your Honor, we would be requesting a PSI as well as a divert screen. I'm not sure where this, do you have the divert ROIs behind the bench?
Is that part of the disposition that there would be a divert screen?
No.
Your Honor, standard practice in our courtroom for a cap allows us to screen for divert as a possible sentencing option since the options are open to the court.
Divert.
Well, I don't insert myself in the middle of y'all's negotiations. Is this acceptable to the prosecution?
No, say no.
You're not going to like my answer,
Say
but
no.
I'm going to rely on your discretion.
Oh, that's awesome. He loves that
Well, my
answer.
discretion would be that if it is a cap of DOC, then yes, it is an option. So if you're not objecting to it, I'll find that this is not in violation of the agreement that was negotiated. We will need that release of information.
Okay, so I am just gonna have you sign right here, okay? I'll fill out the rest.
We have something around.
Listen, as I go through my day, CJ, I have a billion stupid questions that flash through my head. A billion. I need to know this. I need to know that. I need it for absolutely no reason. ChatGPT is ready all the time for my stupid questions, every single day. And no, I mean, I'm not using it. I don't use it instead of a doctor, which is a lie because I don't have health care. So I do use it instead of a doctor, but I don't have the option of a doctor. That's not an option for me. I don't just get to see a doctor ever. If I had to see a doctor, if I was in a situation where I needed to see a real doctor, there's nothing, I couldn't afford it. There's no way I could afford it because first off, if I was in that type of situation, it would be at the hospital. And I literally can't even afford the ride to the hospital. The ambulance is way outside of my. It's over $1,000 to ride in an ambulance. What? Just let me bleed out. ChatGPT, how do I fix a gunshot wound to the abdomen? You should see a doctor. There is no doctor. But now I use it for everything. I use ChatGPT to answer any little question that flitters across my head. I don't think I know, it is a computer. I don't miss it when I'm gone. It's not a companion. I don't use it as a companion. But a real life companion would never be able to handle my amount of questions in a normal day. A normal, if I had a boyfriend, they would go crazy if I discuss with them all the different train wrecks that my mind goes to every day. Yeah, and it can give you normal, what everybody knows about medical information. It's not, I mean, if I had a doctor, I would go to the I wouldn't just say, oh, no, I'm going to use ChatGPT over here. No, I would go to the doctor. I would get the doctor to do what he needs to do. Or she. What's wrong with me? I would get the doctor to do what she needs to do. But I don't have a doctor. I can't go to a doctor. And my lawnmower broke, and ChatGPT fixed it. I fixed my lawnmower because I typed in ChatGPT. And it was stupid. I'm like, usually my lawnmower goes brrr. Now it's going brrr, brrr, brrr. That's exactly what I typed. And he was like, and Google would have broken. Google would have had no idea what I was talking about unless someone typed that exact same thing in Reddit in the last year. ChatGPT was like, silly, go change your gas. Your gas got old. I changed my gas. Boom. All better. Well, except for the front wheels don't turn. But that's a different thing. That's next. I already know what I need to do to fix that. I just haven't yet. But that was ChatGTP. Thank you,
You want
ChatGTP.
December 4th for sentencing? How's December 4th at 8:30?
Fine with the people.
Your Honor, is there anything on December 11th? I am unavailable on the 4th.
All right, December 11th.
Thank you.
That's fine with the people.
All right, 8:30 in the morning on December 11th for sentencing in both cases. We will order the PSI.
Hold on, guys. Time out. I need to take a break. CJ, you know what we should do? We should share our ChatGPT messages for a day. Not all of them, because you would be bored silly if you knew 90% of what I talk to ChatGTP about. Bored silly. But your fleeting questions that you type in there, like, how often does a spider go to sleep? As soon as you type that for a day, me and you should trade those messages. We would learn so much. We would teach each other so much for one day.
And the divert screen.
Thank
You
you.
know, let's really, really, really learn, everybody. Any question you pose to Google or ChatGPT today, put that in Discord. We all want to know the question and the answer. We all want to learn. All day today, if you ask ChatGPT something, put it in Discord. But let's control ourselves. For example, there's a subject matter I talk to ChatGPT about every day, extensively, intensively. Like, I am learning this. It's nothing that you guys would ever care or want to know about, ever. Don't fill up Discord with that. Like, I don't know. I need a question. I need a question. Is there any real food in Doritos? Those are the types of questions that you put in Discord. And we would all learn. No, I think we would learn a lot. I think we would. I think it would be a good day. It would be a funny day. Because you know what? Your question's going to make me think of asking him a different question completely. I say it's a him. I don't know why. My chat GPT is called G. So, that's what I call him. Because I need to call him a name. It just feels weird. It doesn't feel weird not giving Google a name. But it feels weird giving ChatGPT a name. So I call him G. But yeah, let's do that today, guys, all day long. What meat does McDonald's use? You know they don't use meat. Silly boy. Silly boy.
Anything else?
Anything else?
Not to conclude this matter, Judge Schuette, you'll see you back.
No, Judge, I'm done. Thanks.
Yeah, do you have that ROI?
Yes, I just need to add the case numbers.
Okay, thanks.
See, that's a good question. That is a good question. Kos. Anything with kos is sugar. I just want the day where I could put him in the bathroom that he could play my music instead of this
Anybody in the
Google
back not
thing
have an
that
attorney?
sucks.
Anybody pro se?
Pro se, come on, pro se, come on up.
I don't, Your Honor.
Damn.
Rashi.
I'm sorry?
Yay, Rashid does not. We got a pro se, guys.
What's the case number?
I'm not actually
Hold
sure.
on, I'm not talking to you, sir.
Apologize.
Definitely, Zach.
All right, we'll call an add-on on the 4E docket, 23 CR 4822, People versus Sims for the prosecution.
Oh, sorry, Your Honor. This is Mr. Davis.
I thought it was
Oh, I'm sorry.
23 CR
Are you
4822.
calling a WebEx? I'm sorry.
Yeah, I'm calling the one that's on WebEx real fast.
That might be yours.
Stephen Abraham. All right, Stephen Abraham for the prosecution. Mr. Sims is present via WebEx without an attorney. Looks like he failed to appear yesterday through some confusion over how to appear virtually. Mr. Sims,
Prison.
you can't make these mistakes. If you're going to be
Prison.
afforded the
Send
luxury
him to jail.
of not flying in from Michigan, you need to make sure you understand how to use it and you make sure you get into the correct virtual courtrooms. I'll vacate the warrant. Had there been a bond previously?
I think it was a summons, Your Honor.
He's on a summons. All right, sir, have you received a copy of the complaint to revoke your probation?
Yes, Your Honor.
That's why I do that. All right, looks like you were on probation for a, well, you had a deferred judgment to a Class 5 felony, and you were also on probation for a Class 1 misdemeanor. A Class 1 misdemeanor carries a potential sentence to the county jail of up to 364 days. A Class 5 felony carries a potential sentence to the Department of Corrections of between 1 and 3 years, unless there were aggravating circumstances, and it could be as much as 6 years. If you were sentenced to the Department of Corrections, there would be a 2-year period of mandatory parole.
Oh my God, I'm so sorry. I wasn't looking. Monica, thank you for the bits. Thank you for the bits. Hold on. Monica, thank you for the bits. Maria, thank you for cheers. Thank you for the cheers. Thank you. My eyes were somewhere else. I'm so sorry. I was not looking.
It looks like they're alleging that you were ordered to do 50 hours of community service and you have failed to provide documentation for completing that requirement. Furthermore, it looks like you were ordered to complete a substance abuse evaluation and treatment, and you have failed to provide verification of these, as well as an anger management class. You have not provided verification of that. If these allegations are established, then, well, first off, that Class 5 felony deferred judgment, permanent conviction on that felony would enter, and you'd be subjecting yourself to sentencing within the ranges as I explained earlier. Do you understand all of that?
Yes, Your Honor.
Do you plan on getting yourself an attorney?
I can. I'm not sure exactly how I should go about that.
You're the one in Michigan, sir. You
Yes,
gotta
sir.
make it-
Yes,
you
sir.
gotta-
Correct.
You got to figure it out. If you're going to apply
Yes,
for
sir.
the public defender, then you need to call their office and figure out what you can do to get that done. I'll tell
Yes,
you
sir.
right now, faxing and electronics, I've never seen it work. So you'll have to figure out something else. I would recommend maybe getting I don't know, fill it out and a direct email to somebody or something. Otherwise, you can let your fingers do the walking, if that's still a term the kids use today, and find yourself an attorney and hire yourself a private counsel, one way or the other. You're facing very serious consequences here. Frankly, this, of all the reasons I see deferred judgments being revoked, this would appear to be of the most in control and kind of the silliest reasons. But you know, if you're going to
Yes,
get
Your
these
Honor.
things done, I'd suggest you get them done and talk to your attorney and talk to the DA.
Yes, sir. I did do the anger management course. It started on the 1st.
No need to tell me that. You
Yes,
get
sir.
that. You get that. You know, you've got to turn in. It's your job to turn that into probation. So you dot your I's, you cross your T's, you get it done.
Yes, Your Honor.
Tell you what
my
I
officer
will
has
do.
it.
what I will do for now is I will set this matter over for entry of appearance of counsel. We have something about a month out. November 13th at 8:30 in the morning, I will authorize you to appear remotely. Please make sure you get into the correct WebEx. By then, I would anticipate that you will have completed your application for a public defender or hired private counsel and gotten that taken care of. And then we'll see whether or not y'all can work this out with the prosecution and probation. You remain on probation, so
No,
continue to report.
you don't get to slide right by that. And there he just threw in a y'all. He was fixing earlier. And today there's a y'all. Is there a y'alls in Colorado? I'm thinking not. But he just threw one in there when he said fixing to earlier. They're fixing to.
Continue to do whatever you're supposed to be doing. And Judge Schutte, you'll see you back. I'm sorry, what day did we say?
I didn't say your name, Jude.
November 13th at 8:30. Any questions, sir?
No, sir.
I don't
Anything
think I
from the
said your
prosecution?
name. I
No, Your Honor,
can't think
thank
of
you.
All right, you're
anything.
free to go, sir.
Thank you, sir.
All right, who are we ready on?
We're ready on Mr. Davis.
Three
5 Echo,
No, number 3 on your docket.
my docket.
I could. Right, where we got it on? This is the morning.
All right, 24 CR 6605, People versus Tualor Davis.
It's just odd that I've never heard him speak like that before, and then twice in one day.
Entries.
Good morning, Your Honor. Ashley Morgan and Rebecca Casterline for the people.
Good morning, Your Honor. Evan Shaw and Jim Cross on behalf of Mr. Davis. He appears in custody at the podium.
All right, so I
Guilty,
have
Jude, you're guilty.
paperwork here indicating that you wish to plead guilty to count 4. That is a class 2 felony of murder in the 2nd degree. All unprosecuted counts would be dismissed. There's a stipulation between the parties that they've already spoken to the court about, that your sentence would be between 30 to 40 years, and you're agreeing that you'd be liable for any restitution in this case. Is that your understanding of what you're doing, sir?
Yes, sir.
Counsel waive further reading and advisal under Rule 5.
Yes, Your Honor.
Oops. All right, sir. Mr. Davis, how old are you, sir?
28.
And how far have you gotten in school?
I finished high school.
All right, so I presume that you read, speak, and understand English.
Yes.
Are you a veteran of the United States military?
No.
Are you under the influence of any medications, drugs, alcohol, anything that affects your judgment today?
No.
Counsel, you have a
I don't even know what's about to happen. He's here for murder. We went from distributing drugs to a murder conviction. He's pleading guilty to no trial. And 20 to 40 years. Now, what does that mean in Colorado? Let's give him the benefit of the doubt, and judge goes with 20 years. Does that mean 10 to serve, 10 on probation, I don't know. I don't know what the judge is going to do here.
Constitutional obligation to find out the
Again.
citizenship of your client. And if he's anything other than a U.S. citizen, you must tell him the immigration consequences that this plea would have on his specific status. Are you in compliance with your obligations?
Yes, Your Honor.
The count to which you are pleading guilty, Mr. Davis, reads that on August 15th, 2024, you did unlawfully, feloniously, and knowingly cause the death of David Richardson. To that count, do you plead guilty or not guilty?
Guilty.
And before I accept that plea, let's make sure that you understand a couple of things. I understand the agreement, and I've agreed to the stipulation that your sentence would be between 30 and 40 years. But you need to understand that a Class 2 felony by statute carries a potential sentence to the Department of Corrections of between 16 to 48 years. Do you understand that?
Yes.
All right, and since you will be sentenced to the Department of Corrections as charged, it's not the crime of violence, so we're looking at a 3-year period of mandatory parole. Do you understand that?
Yes.
Your Honor, this is a crime of violence, second-degree murder.
I didn't think that was a statutory. There's no allegation of the use of a deadly weapon in the elements.
Yes, statutory second-degree murder. I think it's it's attempt first-degree murder that is not. This is a crime of violence.
All right, then it's a 5-year period.
Wait. Attempted first degree is not a crime of violence. They're wondering if murder is a crime of violence here. They're questioning that. You should ask ChatGPT, Judge. G will tell you that's violence. You could even ask Google. Google will say it's no, it won't. Google's stupid.
Period of mandatory parole. Do you understand that?
Yes.
Oops. All right, so do you understand you have the right to plead not guilty? You have a right to have a trial within 6 months of that not guilty plea. You have a right to be represented by your attorneys at all hearings up to and including trial. You have a right to be presumed innocent of these charges, and you have the right to make the DA prove it beyond a reasonable doubt. At a trial, you would have a right to confront witnesses that are called to testify against you. That means you have the right to question them. You'd have the right to present evidence in your own defense, and you would have the right to have me issue subpoenas ordering your witnesses to come to court and testify during your case in chief. At a trial, you'd have a right to testify or not testify in your own defense, and if you chose not to testify, I would tell the jury that they could not use your silence against you. Finally, if you went to trial and you were convicted, you would have the right to appeal that conviction to a higher court. Do you understand that you have each and every one of these rights?
Yes, sir.
Do you understand if I accept your guilty plea, you're giving up all of these rights?
Yes, sir.
All right, now finally, sir, I do not accept pleas of guilty from people who tell me they've done nothing wrong. That is what trials are for. So now I'm going to ask the DA to tell me what facts she would prove at trial that support this charge. And when she's done, I'm going to ask you if that's what happened. Counsel.
Yes, Your Honor. On August 15th of 2024, Mr. Davis was hanging out with the victim, David Richardson, in the defendant's apartment. The defendant shot Mr. Richardson in the back of the head, knowingly causing his death. And the defendant and co-defendant Jonathan Davis, who was his cousin, cleaned the apartment, wrapped the body in a comforter, and dumped the body in an alley.
All right, is that what happened?
Yes.
All right, understanding the rights you're giving up, understanding the potential penalties, you still want to do this?
Yes, sir.
All right, then I'll accept your plea, finding you've entered into it knowingly, intelligently, and voluntarily.
Oh, you know the victim's family is here. You know
I need
it.
my second cup of coffee. I guess causing death does qualify under 18-1.3406.
Thank you, Your Honor.
Yeah.
Yes, it's a per se crime of violence in the statute, but
He asked
I'm glad you brought it
ChatGPT.
up and we clarified.
He did. He asked ChatGPT while we weren't looking. It's because he didn't ponder. That's what happens when
Are
this
we
judge
taking
doesn't
PSI?
ponder.
Yes, please.
I would, if the court could note that the defense would like to be present for the PSI, appreciate that.
Yeah, we will order the PSI. We'll note that the counsel for the defense should be consulted so that they can be present. And we will set sentencing about December, December 1st. That work for everyone?
Works for the defense.
I believe that Ms. Casterline is in a trial.
We need both of y'all for sentencing?
Sorry, what was that, Your Honor?
We need both of y'all for sentencing?
We can accept the date.
All right, December 1st, 8:30 for sentencing. We'll order the PSI. Defense wants to be present. We'll vacate the 11/17 date. Anything else? That'll conclude this matter.
Thank you, Your Honor.
Thank you.
And we can next call Richard Chavez. Chavez.
21 and 22. In the court's docket.
I love this judge. I don't know why.
All right, 24 CR
Nothing exciting is
3050,
happening.
24 CR 2741, People versus Richard Chavez, Mr. Aziz for the prosecution, Mr. Swetzka on behalf of Mr. Chavez, who is present in court out of custody. We're set for hearing on probation revocations in each of these cases. Are we ready to proceed?
So, Your Honor, in speaking with Mr. Aziz and Mr. Chavez, we have reached an agreement where Mr. Chavez would admit to the violations of his in-home monitoring, but we are asking the court to accept the stipulation to resentence him to an additional 30 days of in-home monitoring. And we think we can explain to the court some of the issues and structural challenges and logistical challenges that Mr. Chavez faced. And hope that we can have those ironed out so that probation can accommodate some of those needs that Mr. Chavez has so that he will be fully compliant for this regrant of 30 days in home detention.
Well, if you want to convince me it's appropriate, go ahead.
Okay, so, I know it seems like a lot of violations when you look at how it is listed out for 26 minutes, 17 minutes, et cetera, various hours on different days. You add all of this up, Your Honor, for the listed violations, it adds up to 9.5 days out of a 90-day sentence that is sort of at issue here. Additionally, they noted that there was 267 violations lasting less than 15 minutes. If we assume that those each were 14 minutes, sort of getting the maximum under the threshold there, that only adds up to an additional 2.5 days of in-home.
The fact that he violated the order by 10% isn't mitigating.
Well, so I respectfully, I think I disagree, Your Honor. And I would just point out that there are.
I want to hear the why.
The why.
I don't care about the how much because there's no excuse for it and it's not mitigating in my opinion, and I am the one sentencing.
The why.
So the why is the issue.
The why, Your Honor, is that 5 hours violation for going to a methadone clinic is a reasonable period of time to be away from his home when it takes him 2 hours one way with a 3-bus transfer to get from Xanadu Street to 13th Street.
Why is that a violation?
These are some of the.
You're not clearing this with them?
So some of this was cleared with them, and he has provided documentation of the various times that he was going to the methadone clinic, Your Honor. But I think overall, a lot of these violations, when we look at them, they can be explained for the times that it takes him to utilize public transit, which is a lengthy and slow means to get around the city.
Well,
to
look, I'm
get-
just trying to cut to the chase. If he's going to a methadone clinic and he's cleared it with probation, then there's not a violation.
Right.
I've got a hard time believing that probation is sending to me violations of probation when they know he's going to a methadone clinic and he's trying to get to and from a methadone clinic.
I mean, probation did note a few of those, specifically that he was approved for an appointment at like 9:30 or 8:30 in the morning,
few
and
of
then a
those.
return at 1 or 3 p.m. or something along those lines. And they note that he did provide documentation that he got to his appointment. But I think what they're missing in the through line here is the length of time that it takes him to use the public transit. There's one specific violation that's noted for August 18th, where they noted that he was supposed to appear at court at 8:30. I looked back in the court record. The court case wasn't called until 11:17 in the morning. And then I think he had returned sometime that afternoon. But even from here downtown, it still takes him an hour and a half, 2 hours by bus to get back to his residence. And that's
Then what about the unexplained ones then?
Zach, you want to see something? I'll be right back, guys. I'm going to show Zach something. Just play with the judge for a minute.
So the unexplained ones, and speaking with Mr. Chavez, and I think this is where the acknowledgement of his lack of foresight in the items that he needed to communicate with probation. He relies primarily on getting food from a food bank. He was going to a food bank in Broomfield. That's a very lengthy trip for him to go to from his residence on Xanadu Street. That's just south of the Arsenal. And I think just overall, Mr. Chavez is aware of the strict compliance that's expected of him on this moving forward. And if we can just have him communicate how he needs to go about getting the basic necessities of life, his food, his medication, his treatment, and incorporate into that a reasonable expectation of the amount of time that it will take him to utilize public transit to get to those locations, he should be able to be compliant and successful if the court simply regrants him for an additional 30 days.
Mr. Aziz, do you agree with the characterization of these things? Because frankly, if this is all legit trying to get food and trying to get methadone, then we should just be withdrawing the complaint and terminating successfully. There's no reason to punish him.
That's his job, sir. The lawyer's job is to say exactly what he said. Hold on. Before you rashly hop into anything, where's your pondering today? Give the prosecution a chance. There is more, I bet, to this story that lawyer just decided not to say. So my guess is, from what I heard so far, there have been multiple missed, and only some of them have valid excuses, but the rest do not. Zach, are you still here? My kids went to Hershey Park yesterday. Hershey Park is a big amusement park. You know, Hershey chocolate. They have a big amusement park, huge. Not like a small town amusement park. It is a very big amusement park. And right when you walk in, so they redesigned the park over the last couple of years. So it's not actually right when you walk in anymore. It's in just a little bit. They have this where they make the popcorn, the candy, the kettle corn, right there in the great big kettle. You can watch them make the kettle corn. This is kettle corn, and if you look, I don't know if you can see, it is not covered in sugar. It's not brown. It's not a solid caramel brown. It's real kettle corn. It's popcorn, and it's sweet, and it's delicious, but it's not like normal kettle corn that's covered in a thick, crunchy shell of sugar. This is actually, yes, it's like Six Flags. That's exactly what it's like. It's like Disney World, but way smaller and with way more roller coasters. But no, I guess it does have characters. Yeah. This is delicious. This is Like, you can go and buy Cracker Jacks and be happy. But then you can eat just fresh kettle corn and, you know, you sing with angels. No, CJ, you gotta taste it. You gotta. It's not sickening sweet like Cracker Jacks. Although I love Cracker Jacks, I'm not gonna lie. I love popcorn. But it's just so, it's unbelievably, unbearably delicious. So they spent the huge amount of money that it costs to get me some popcorn. Oh, sorry. Okay, we are about to hear the prosecution say what I think he's going to say, that there was multiples, and only a few of them have excuses. But I don't know. I haven't seen it. Here we go.
Your Honor, I think Mr. Swetska's read on the file is generous to Mr. Chavez. I think there's plenty of truth to what counsel is saying, but there are periods of time that go well beyond what I think is a reasonable amount of time. By and large, however, and the reason why I was willing to make this recommendation is the pretty frequent and consistent communication that the parole or the probation officer had with Mr. Chavez. Mr. Chavez was reaching out about several of these issues. So I don't believe that each and every violation can be explained by simply time of travel. He was specifically.
I've actually come to Denver and tried to take the bus to Adams County. And if you miss your transfer, it's like 8 hours.
That being said, Your Honor, the frequency with which he was out of compliance, specifically on days that were not dates that he had appointments, even for a short amount of times, was concerning. It was things where he was being, the strap and device were being adjusted. He was advised on what to do inside the home. So I do think that there are valid violations. Even outside of the straps, there was a hot UA, there was some other relatively minor non-compliance. But I think there's sufficient non-compliance to justify a revocation with that 30 days re-grant. So I think all things considered,
Thanks,
I'm not
Zach.
taking the position that Mr. Chavez needs to be incarcerated, particularly given his many medical issues and the fact that he was explaining to the PO some of the issues he was facing. But I do think that there is sufficient non-compliance to justify an additional sentence.
Mr. Chavez, you understand that on the 24 CR 3050, you were on probation for a class 1 misdemeanor, and a class 1 misdemeanor carries a potential sentence to the county jail of up to 364 days.
Yes.
And you understand the DM1 that you were on probation for in 24 CR 2741 carries a potential sentence to the county jail of up to 180 days.
Yes, I remember.
And it's my understanding you wish to admit that you violated the terms of your probation by leaving the house when you shouldn't have been.
Yes.
You understand you're allowed to have a hearing. You're entitled. You have a right to have a hearing on that. You have a right to be represented by your attorney at that hearing. And at that hearing, the DA would have to prove that you committed those violations by a preponderance of the evidence. Do you understand that?
I understand that.
Are you thinking clearly today?
Yes, sir.
Understanding the potential penalties, understanding the rights you're giving up. Do you still want to do this?
Yes, sir. I absolutely do. I think I can do this.
All right, I'll accept your admissions then, find that you've entered into them knowingly, intelligently, and voluntarily. I hope you can,
I can.
because look, man, the truth, in my experience, probably lay.
You don't hear any truth. You're a judge. All you hear are lies. Nothing is ever the truth from what you hear. So how do you know what the truth is? Guys, go subscribe to those 2 channels, because it won't. Okay. Normally it's really, really not good to subscribe to a channel if you're not going to watch the videos. Because what happens in YouTube world is when you release a video or a live stream or a short, YouTube shows your subscribers first. And if they don't watch and they don't care. YouTube's like, well, yo, your besties aren't going to watch this. Why in the world should I show it to anybody else? And then it doesn't at all ever show it to anybody else. So don't subscribe if you're going to screw him over. But here's why I say subscribe. He has content that you will enjoy. This is stuff that you will enjoy to watch. I'm not asking you to subscribe to a carpet cleaning video. This is something that you can pop on, but watch it till the freaking end. It won't kill you. When you click a video, watch it to the end. Because when you bounce out halfway through a video, come on, that's hurting these people. These people are trying really hard. So subscribe if you're going to watch. If you're going to watch. And if you're going to watch to the end. It's only a couple of minutes of your life. Well, that's not true. So, like, some of the content's a couple hours long. You don't have to watch to the end of that because YouTube knows people are going to bounce. It's okay. Watch a healthy amount and then bounce. But the littler ones, a 5-minute video, you can't sit down for 5 minutes and watch to the end. You gotta bounce at 2 minutes. No, that's rude. That really, really is rude. Don't do that. Oh man, you know what? We should all pick one and see if our Vibers can move a needle. Hold on. I know which one he wants us to do. Judge decides between competency and copy machines. But I wonder if us Vibers have the power to go back in time a little bit and bring a past video to life and get it clicks it deserves. Okay. Alright guys, I'm going to put a link up. Listen, at some point today, even if you're on Replay Crew, we are all, every single person watching this live, try to go to this one video. It was from 3 weeks ago. And we're going to see if we can't wake it up a little bit and get it retested. We're going to try. Oh wait, I clicked it. Now I just used some of his content on my channel. Zach, please, buddy, do not. Don't report me for that. It was an accident. I'm not stealing your content. That would be messed up. Wouldn't that be messed up if he reported me for stealing his content because I clicked it by accident? There, that's the video. At any point today, at any point, press play. It is 4 minutes and 31 seconds. You all can do that. Just press play. Yeah, I'm going to put it in Discord. I'm actually even going to put it somewhere special in Discord. I'm not even... Okay, now maybe 3 people will. All right, back to work, guys. Stop messing around.
Somewhere in between. I've got no doubt there's, in my heart of hearts, there's gamesmanship going on. I also have no doubt that there's issues with the transportation and things of that nature. The next 30 days, you had better be an excellent
Tina, you're a rock
communication with
star.
probation
You're elite.
and don't play games. I'm not doing this again. We get another revocation. We're just
Yes,
going to
you
do some
are.
jail
See you on
time and be
Monday.
done. Had way too much on these cases. You sure you want to do this?
Yes, sir. I just lost my brother. He just
I didn't
died.
ask. I just want to know that you can make it through
Yes,
this.
I can.
Yeah.
All right.
There's not gonna be no games. It's gonna happen.
Then do it. I'll order you 30 days of probation with the condition of 30 days in-home with the monitoring. Anything else?
I would just ask that the court make note that the previous permission that was granted by the court for his methadone appointments is continued for this new sentence. And just making sure that the probation officer does not have to file a request with the court to grant him permission to go to any medical appointments, and that he can be given permission to schedule times to go get groceries or other food with probation that does not need a request approved by the court. 'Cause I don't want there to be a lag there where he's.
It'll be the same terms and conditions. And yes, you can go get food. Yes, you can go to medical. Yes, you can go to the methadone treatments. That doesn't mean that you just get to, they have to believe you that I've got an appointment. They may say, we need proof, and you've got to provide them proof. All right, good luck. I hope I don't see you back.
Thank you, Judge.
And then just point out to her again how long it takes you to.
All right, every once in a while I see this judge and the color of his shirt makes it look like he doesn't have a shirt on, he just has a tie on.
Counsel.
Good afternoon, Your Honor.
This is
I
Mr.
love Law
Elo.
Talk with Mike.
Elu Omar
him.
from the 5E docket, Your Honor. It's an add-on.
My favorite for Law Talk with Mike is when he says things like, if I did that, they would cart me out in handcuffs, because he's a lawyer. You know what I mean? So when he says that, you know, I can imagine, yeah, lawyers can't do that crap in a courtroom. Yeah, I bet he doesn't have pants on because it's hot in Colorado. It was on the 10th when this was. It might not be today. You know, Kelly said this front is moving through, and I don't know if it's cold or not. But, so he's not wearing anything underneath. I wish I wasn't, because it's freaking hot in here. I'm dying.
Oh, I'm sorry. So not counsel.
Zach, what does that mean? What do you mean, the 360
All right,
resolution?
23 CR 4875 people versus
I will fix it if I know what that
Omar
means.
for the prosecution.
Good morning, Your Honor. Steve Abraham and Michelle Christopher for the people.
All right, Mr. Omar is present
Time
in
to ask
court in
ChatGPT.
custody, representing himself. We are set for, I guess, a pretrial conference today. Prosecution just wants to make sure that all systems are go. Mr. Omar, are you ready to proceed to trial?
Your Honor, I'm going to be requesting appointment on behalf of Mr. Omar, understanding that I previously requested appointment as advisory counsel. In our meetings, we've come to the conclusion that Mr. Omar is not going to be able to proceed pro se.
Why?
I filed my entry of appearance on his
Why?
own because he doesn't have a license to practice law, Your Honor. And,
That's not a reason not to go pro se. That does not make him incapable.
Your Honor,
In fact, I'm the one that had the conversation with him about exactly this, and he understood everything, and he waived his rights to having an attorney, and I'm not sure it's appropriate to appoint you. I don't think I found a conflict with the Office of the Public Defender, so I don't think there's a reason to appoint you.
I'm private counsel, Your Honor.
So you're not asking for appointment, you're asking to enter.
Correct, Your Honor. And I apologize for the confusion.
Well, it's dollars and cents, which in this day matter.
And we're prepared to address.
Well, and I'm not convinced that it's appropriate at this time, at this late hour. He knowingly and intelligently waived his right to counsel. He said he was going to represent himself. This case has been continued previously, and now we've got a last minute. I mean, we're set for trial. The case is set, for trial in 10 days, and this feels like gamesmanship. This feels dilatory. This feels unjustified. And the only thing you've told me so far is he doesn't have a law license. That's not a reason to continue this or to appoint counsel at this time. You've been on the case as advisory counsel. You ready to go to trial on the 20th?
Yes, Your Honor.
So a couple days ago, I was getting these error messages from YouTube for my live stream saying that my bit rate was way too high. It was near 7,000, and YouTube only wanted 2,500. So I did. I went in and I manually changed it to what YouTube said that YouTube wanted. So I did that, and YouTube is still complaining at me right now, saying my bit rate is way too higher than recommended. It's saying my bit rate at 2,651.62 is higher than recommended. I don't think these are deal breakers for YouTube. So I'm going to try right now to go back and put it back up to what I had it with for the last few months. Because YouTube can complain all at once. And that should fix it. Or my whole stream is about to crash. One of those. About to happen.
And where are we then on the my understanding is that there was an expert, and thus far there have been no reports turned over. So we not going to present an expert?
We will not be calling Mr. McKee, Your Honor.
Is that the counsel? Is that the expert in question?
Yes, Your Honor, that's the motion I filed, and in speaking with Mr. Camera today, that would take care of that issue. Obviously, I think that's a final decision, and that decision cannot be changed given the lack of a report or endorsement.
Well, we're all aware of the factors, and pronovost, I think, is the case. So, but at this point, it doesn't look like that's going to be an issue. All right, counsel, I'm sorry. What was your name again?
Anthony Camera, Your Honor, 56432.
Camry?
Camera like a Kodak.
Old school. Does Kodak still make cameras? Oh. All right, so you're telling me that if I appoint you, if I allow you to enter your appearance, you're not being appointed. This isn't a situation where the state's going to be paying you as ADC. If I allow you to enter your appearance on this case, you're prepared to go to trial on December 20th?
October 20th.
October 20th, thank you.
Yes, Your Honor.
Mr. Omar, this is your right to represent yourself. And you told me you wish to represent yourself. Is it now your wish that you actually be represented by counsel?
Yes, Your Honor.
All right. And any other questioning or voir dire or any other issues the prosecution think the court needs to engage in?
There was a second issue that I filed in my motion about subpoenas, and in speaking with Mr. Camera, it's my understanding that they are prepared to go to trial whether or not they have the witness, particularly Mr. Guzman, present in court. So
Well, I
I
guess
would,
you've made explicit that which was implicit. Mr. Cameron has
Mr.
indicated he-
Guzman, what did he do? Just so you know, guys, Victoria's husband's name is Mr. Guzman. Yeah, it is. What did he do?
ready to go to trial on the 20th. So I
Yeah.
assume that takes into consideration all issues.
yes, and because this victim is coming out of state, whether Mr. Omar changes his mind about pro se or higher counsel, we are planning to move ahead full steam, and we'll be vigorously objecting to any continuance on the morning of the 20th.
All right, well, at this point, I will allow Mr. Camera to enter his appearance. Have you filed that? You did-
All right, I just found out I cannot change it from 360 midstream. So this whole stream is going to have to stay this way, but yes, Michael, but it will not. It will not be like that anymore.
Did it, is that on the 17th? Is that yours?
That's correct, Your Honor.
All right, so I do have an entry of appearance by Mr. Camera I will accept that entry of appearance on the, strictly because he has indicated that he and Mr. Omar are prepared to proceed to trial on the 20th. There is no motion to continue at this time. I do not anticipate that there will be one, given the representations that have been made to the court. I will tell Judge Schutte that this case is proceeding to trial on October 20th. Anything else from the prosecution?
I don't believe so, Your Honor. We're ready to go.
Counsel?
Your Honor, I believe there are two outstanding motions in limine, which I just wanted to make the court aware. In my conversations with Mr. Abraham, I believe we're going to address those motions in limine on or before the morning of trial, but otherwise.
Yeah, I would anticipate, well, I think most judges handle motions in limine morning of trial, and I would assume that's Judge Schutte's practice. If you think it takes more time, then file something to add it on, ahead.
I just cannot think of Judge Schutte. So I wonder if I need to look around Colorado and find a different place they're live streaming, because okay, there are hundreds and hundreds and hundreds of judges in Colorado on this site. No, I don't know them all. I don't. But normally I don't, he doesn't slap me with a judge that I just cannot place at all. I've seen them all, at least, so I think I need to do some research tonight. I think they're hiding some live streams in Colorado from me.
At a time, but
She's aware of those, and the last pretrial conference we had, she indicated that we're expected to be in court at 8 o'clock on the 20th.
well, and the one of them, in my quick review, one of them was a prophylactic rape shield, but if the defense hasn't complied with the rape shield requirements, then that's kind of a non-issue anyhow. But so I think it seems to me that Judge Schutte can deal with these things
I agree, Your Honor.
morning of trial. All right, thanks everyone.
Thank you, Your Honor.
Okay. I'm sorry, I should have looked at my time better. Poor time management. That's what happens over here. Well, we made it. This is day one of this monster week I'm about to have. So again, content this week is not going to be great, but what I plan on trying to do today, and I don't know if I'm going to be able to do this, but I plan on trying to upload a few live streams as premieres. Pay attention, because this is going to confuse the hell out of every single person. So try to pay attention. I'm going to explain it to you now. And then later, everybody's going to be confused anyway, but this is how I have to do it, I think. I'm going to try to create 2 or 3 live streams today and upload those as premieres. Hold on. Just wait. Because I'm having a monster freaking week this week. Really busy, lots of work, working every single day. I am terrified that I am going to miss an alarm clock on a day. When I'm exhausted, I'm exhausted and I don't have the alarm clock. What I plan on doing is uploading a few live streams, scheduling them as premieres, just in case I don't hear the alarm clock. So what's going to happen is I'm going to wake up every day and hear the alarm clock because I'm a responsible adult. 2 weeks ago, I was sick. I was really sick. So I didn't hear the alarm clock, and I think I missed 2 streams or whatever. This is just in case. This is just a fallback plan. If I get exhausted and I miss an alarm clock, that premiere will click on, and it'll be like a real live stream. I just won't be here. But if I do hear the alarm clock and wake up, I'm going to cancel the premiere and just do a normal live stream like normal. So here's what's going to happen. You guys are going to see the premiere. And then I'm going to cancel the premiere because I'm here. And then what's going to happen is everybody's going to lose their mind and be so confused Was there a live today? Yes. I'm here. I started the live. I canceled the premiere. So I know that's going to be confusing. I already know. I had to weigh the options. I either miss entire live streams or I confuse you. I would rather confuse you. So I'm going to create premieres today if I can. If I can. I'm going to schedule them. And then if I wake up on time, I'm going to cancel them. I plan on waking up on time. I really do. I plan on it. But sometimes I get exhausted and then I don't hear the alarm clock and then you guys sit around for hours and wait. And that sucks and I feel like shit when that happens. So this is just plan B, just in case. So you guys don't sit around and wait and wait and wait for something that's never going to happen. That sucks. I hate that. So everybody get ready to explain it in chat. Because people are going to be confused. I'm doing my best. All right. Kelly, I promise you, you are going to be fine. You are. You are stellar at keeping that apartment perfect. So, all right, guys. I'm going to start OJ. We're finishing. Oh no, it's DNA again today. Listen, don't come to OJ today if you don't want to listen to DNA. Bye guys, thank you. Dude, I love this song so much.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace, come join the fun. It's a welcoming place. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so